This week we're going to talk about the opinion process for state attorneys general. All state attorneys general have the authority to issue formal opinions, and they've always had that authority. It goes back a long time. And in doing so, they provide legal advice on issues large or small, usually to government entities, and because they're public, to the general public as well. Now this week we talk about the factors that go into making that decision. When do you issue them? When do you not? And then what difference do they make anyway when they're done? The best single description of the opinion process is contained in the NAG Powers and Duties book in a chapter written by NAG counsel Emily Myers. We also include on our syllabus a collection of a potpourri, if you will, of AG opinions, when they were issued, when they weren't. Any particular and rare federal district court case where an AG opinion from Kansas was struck down to show you the significance and the meaning that some opinions can really have. But even though these readings describe the basics of AG opinion processes, they don't really say what happened and how it happened. So that's why I'm going to lecture for you just a little bit on that subject. Now, believe it or not, we once lived in a country when we didn't have a lot of lawyers. And so people needed to go all kinds of places to get legal advice, which is where the AG opinion process and how it originally ended up in the statutes of every state. But as government became more complicated in the 60s and the 70s, not just because of the substance of the laws, because government wanted to do more, and the U.S. Supreme Court was both granting rights to government and restricting rights of government, legislatures decided that they better pay attention to the processes that were being followed in making laws and regulations. So they passed Administrative Procedures Act, they guaranteed due process, they passed Freedom of Information Act so we could all know what was going on. And basically, state government was no longer a place for the good old boys to sit around and pass out the government money to their friends. So, into this process, obviously, involved more legal decisions, more complexity, and because that opinion process was sitting on the books of attorneys general, that is where many people started to file opinion requests. Now, the statute says it's not like anyone can ask. You have to be a state legislator or a mayor or a governor. But it isn't hard to find someone to ask a question for you if you give it a shot. So the question is, how do AGs handle these? When I became Attorney General, I found, just at the cusp of this issue, the AG's office was issuing 100 opinions. We had more or less 5 assistant attorneys general out of a staff of only 100 who were writing opinions all the time, and they liked it because opinions aren't advocacy pieces. The lawyer writing an opinion is supposed to be like a judge. They're looking at both sides and trying to be fair and honest and calling it down the middle. Well, I didn't become Attorney General to be a judge. I became Attorney General to be an advocate, to provide good legal advice to state government, to enforce the law against people who broke the law, and to generally be a legal advocate. And issuing AG opinions just didn't fit into that. So I decided I was going to cut it back. But I didn't issue a rule as to how to do it. I just kind of used, frankly, my own judgment. And the first thing I decided was that the requests were almost always legitimate in the sense that they reflected that somebody had a problem somewhere. So I thought, as the AG, we should go solve the problem. Rather than write a legal opinion, let's go find out what's really going on. So that involved a lot of one-on-one meetings, long discussions, and generally, once you determine what the problem was, you could resolve it without a formal legal opinion. They got rid of a lot of opinions. Okay, I did have a few rules. The first rule was that if the opinion request was based on facts, especially if they were controverted facts, there wasn't going to be an opinion. The opinion process is about writing what the law is, not determining facts. So that got rid of a lot. The second thing was that many of these requests dealt really with subjects that arose within the jurisdiction of a state agency. And if the state agency had jurisdiction, we would treat them as a client. We would give them advice, informal, verbal advice, or we would give them informal written advice that was protected from the public by the attorney-client privilege. And again, and sometimes we'd have to tell the client, look, the law is too vague, you can't do this, maybe you should go back to the legislature. But we were treating the agency as a client. We weren't jamming legal opinions down their throat that they didn't have any involvement with. Well, the third thing we did, if we were in litigation or we knew it was headed to litigation, no AG opinion. That means we're going to court, we'll let the judges decide that. So then the fourth thing was if the AG was going to sign this opinion, that meant it was going to be the opinion of the whole office. That meant taking the AG opinion away from the assistant AGs who were initially drafting it and circulating it through the top of the office. And so invariably, and not surprisingly, these opinion requests ended up in the offices of Solicitor General as they started to become formed around the country. And then finally, my position was AG opinions should be right, they should be good, and they should be rare, and they should be a big deal. They shouldn't be just normal behavior of state government. So I pushed this approach in my own office. We ended up giving 5 to 10 opinions a year by the time I was done. When I began consulting for attorneys general in the 90s, I took this on the road. I wrote a series of guidelines. The guidelines were adopted word for word in Arizona, and then Washington, and then Illinois, and pretty soon we had gatherings of solicitor generals. And a consensus has formed due to the insights of many assistant AGs with a lot of experience as to when an opinion should issue and shouldn't issue, and that consensus is reflected in the NAG chapter that's written so well by Emily Myers. So that basically is it. That doesn't mean you never do opinions. AG opinions make a lot of sense. Sometimes they can really solve a problem. Let me give you an example. We have a state agency in Maine, the State Board of Medical Examiners, who was just refusing to follow the law. They didn't want to allow applicants who had gone to certain medical schools to become doctors in Maine. And my assistant AG had told them they had to do it, and they just refused. So, and they all had money, so they hired their outside lawyers who said didn't know what we were talking about. So what we did was we issued an AG opinion, a formal opinion, saying that the agency had to let these doctors, applicants, take the exam. Predictably, the board ignored it. I allowed them outside counsel. They went to the Maine Supreme Court. Maine Supreme Court ruled that the opinion was correct, the board was wrong. And not only was that good on the merits, but the court also got to see, if we let people go around the AG's office, we're going to have agencies in our door all the time trying to cut an angle, cut a deal. And so it was a very good case, not just on the principles. It's Stone versus Maine Board of Education, the 1986 case. But here's another example. The Attorney General of Arizona in 2006 was faced with an anti-immigrant immigration referendum. There's no other way to describe it. That's what it was. And he was personally opposed to it. But if you looked at the wording of the referendum, which was going to the voters, had not come from the legislature, there was a moderate interpretation and there was a radical interpretation. So he issued an Attorney General ruling in the middle of that campaign that adopted the moderate ruling. While the referendum passed, predictably, those who wanted the radical interpretation brought a lawsuit to invalidate the AG opinion, and that went to the Arizona Supreme Court. And again, the court said, we're not going to second guess the AG on this. This was out there. The voters understood this is what it was about, and so they let the more moderate interpretation last. And there's a law review article on that by a student of mine, Addison Thompson, in 2007, which describes this in some detail. Okay, so that's the process. Who cares once they're issued, right? It's just, obviously people don't like it, say, well, it's just one man's opinion. Courts don't have to go along with AG opinions, but they generally do. They listen carefully. As we saw in the Maine and the Arizona example, they listen because an AG opinion represents the well thought out consensus view of an important institution in the state that is there to give legal opinions, especially regarding state constitutional issues and state law. So they do listen, they take them seriously, and they're cited all the time in state constitutional law decisions. Agencies also, well, they may not like the opinion, but they sort of have to ultimately listen to it because they can't go to court without it. But the one group of people who are definitely restricted by an AG opinion are the AGs themselves. In other words, the AG's office can't argue inconsistently with their own opinion. They just can't do it. It doesn't have any credibility. Their opinion will be used as evidence by the other party. And it also provides protection, immunity protection for state employees in a tough call. They can say, look, I was just following the Attorney General opinion. So it does play that valuable role. So rare, right, and correct. Now, is the process abused? It certainly is. New AGs, generally new AGs, will often abuse the process because shortly after coming into office, they're approached by constituency groups political supporters, whether it's a labor union on the left or an advocacy group that may have a more conservative view, whatever it is, they're saying, here's an interesting draft. Why don't you issue this as an opinion? Occasionally AGs do that, and when they do, well, you saw what happened in the Kansas case. The courts can step in and say, look, this is a political thing. This isn't really a serious AG opinion. So there we have it. They're rare, they're good, they're important, and they're a tool that's in the toolbox of every Attorney General.